we're back online, my friends. Hello, hello, hello. All right, YouTube's back working the right way. I can see me, I can see you, and we are doing the thing. All right, we are reading tonight from Modern American Remedies, which sounds French, but it's actually American because that's what it's fucking called. All right, we are reading from Wiling versus Mazzocone, a Pennsylvania or Pacific Court case out of 78. Madarino is the justice for today. So we have, this is a very odd case. So just stand the fuck by and get ready because it's a wild ride. All right. So on Monday, September 9th, and Wednesday, October 1st of 1975, the appellant Helen Wiling demonstrated in the well-traveled pedestrian pathway between two court buildings located at City Hall and at 5 Penn Center Plaza for several hours each day. So she was a protester, sign holder, right? The appellant wore a sandwich board sign around her neck. On the sign, she had a hand lettering wording which declared the following, quote, law firm of Quinn Mazzocone stole money from me and sold me out to the insurance company, end quote. And she marched back and forth. Appellant also pushed a shopping cart on which she had placed an American flag. She continuously rang a cowbell and blew on a whistle to further attract attention. So, maybe she had a fever, and the only prescription was more cowbell. We don't know, but we're gonna find out. Appellees in this case associated in the two-member law firm of Mazzocone and Quinn. When appellant refuses appellee's efforts to amicably dissuade her from further activity, such that, as described above, appellees filed a suit in equity, seeking to enjoin her from further demonstrating. They're saying, hey, stop your shit, woman. Here we are. In 1968, appellees who have specialized in the trial of workmen's compensation matters for several years represented the appellant, so they represented her in a workman's comp case. Appellant was awarded permanent and or partial disability benefits, which she has collected for a number of years. This sounds sus. At the time of the initial settlement distribution with appellant, appellees deducted the sum of $150 for costs for filing her case. The sum, according to appellee's evidence, was paid in full to Robert DeSilvero, medical doctor, the treating psychiatrist who testified on behalf of the appellant in the workers' compensation matter. Appellees presented copies of their record covering the transaction with Dr. DeSalverio, a canceled check for the amount of payment, and the testimony of Dr. DeSalverio himself confirmed appellee's account of this transaction. Appellant offered no evidence other than her testimony that the cause of her antagonism towards appellees was not in dissatisfaction with the settlement, but rather her belief that appellees had wrongfully diverted themselves $25 of the $150 that was supposed to have been paid to Dr. DeSalverito. Based on this evidence, the equity court concluded that appellant was, quote, a woman firmly on the thrall of a belief that they had defrauded her, an idea fixe, which is an obsession, literally a fixed idea, which either by reason of eccentricity on her part or even a more serious mental instability refuses to be dislodged by the most convincing proof to the contrary, end quote. The court then enjoined the appellant from any further unlawful demonstrations, picketing, carrying placards which contained defamatory or libelous statements, and or uttering, publishing, or declaring the defamatory statements against the appellees herein. On appeal, the Superior Court modified the trial court's order, which read, quote, Helen R. Wiesling is a permanently enjoined from further demonstrating against and or picketing Mazzocone and Quinn, attorneys at law, and also by uttering or publishing statements to the effect that Mazzocone and Quinn, attorneys at law, stole money from her and sold her out to any insurance company. The case raises serious and far-reaching questions regarding the exercise of the constitutional right to freely express oneself. We believe the orders here issued are clearly prohibited by Article 1, Section 7 of the Pennsylvania Constitution and by the Goldman Theaters versus Dana decision, a 1961 case. Article 1, Section 7 of the Pennsylvania Constitution says in part, quote, the free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty, end quote. As we emphasized in the Goldman Theaters case, Article 1, Section 7 is designed to, quote, prohibit the imposition of prior restraints upon the communication of thoughts and opinions, leaving the utter liable only for an abuse of that privilege. Emphasis added. History supports the view that the framers of our state constitution intended to prohibit prior restraint on any Pennsylvanian's right to speak. After the demise of 1694 of the last of the infamous English licensing acts, freedom of the press and at least freedom from administrative censorship began in England and later to the colonies to assume the status of, quote, a common law or a natural right, freedom of speech. See State versus Jackson, a 1960 case. Blackstone, the author of Blackstone's Laws and Commentaries on the Law from Britain, right? So recognized when he wrote, quote, from Blackstone, the liberty of the press is indeed essential to the nature of a free state, but this consists in laying no previous restraints upon publications, and not in freedom that censure from criminal matter will be published. Every free man has an undoubted right to lay what sentiments he pleases before the public. To forbid this is to destroy the freedoms of the press, but if he publishes what is improper, mischievous, or illegal, he must take the consequences of his own testimony. That's quoting from William Blackstone, Commentaries on the Law of England, a Clarendon 1769 publication. Our conclusion is that the equity court violated the appellant's state and constitutional rights to freely speak her opinion, regardless of whether that opinion is based on fact or upon fantasy. Regarding appellee's professional integrity, obviates the need for any discussion here of federal law. Basically, because she's saying crazy shit, we don't need to discuss federal law, because even though she's saying crazy shit, it's part of the constitutionally protected Pennsylvania Freedom of Expression Incorporated statute or constitutional provision, right? Our resolution should render unnecessary any discussion of the Superior Court's proposed exception to the so-called traditional view that equity lacks the power to enjoin the publication of a defamatory matter. We do believe, however, that the Superior Court's observation that, quote, in the present case, an action for damages would be a pointless gesture, since the appellant is indigent. There is a homeless woman without funds out there wearing a barrel and a sign around her neck that says, these lawyers are selling you out to insurance companies. And for the court to grant a monetary damage against her, given her particular mental state, would be pointless because she has less than no money, so you can't go get money from her, right? So, at any rate, We cannot accept the Superior Court's conclusion that the exercise of a constitutional right to freely express one's opinion should be contingent upon the economic status of the individual asserting that right. Whether you're homeless or Donald Trump or Rich or P. Diddy, who's now running from the cops, or whoever else, right? Joe Biden, Hunter Biden, Donald Trump, Don Jr., whatever, right? Doesn't matter on how much money you have or don't have. It does not limit your freedom of speech. The court is doing a good thing here. They're doing a good here, right? Conditioning the right of free speech upon the monetary worth of an individual is inconsistent not only with our fundamental principles of justice that are guaranteed by the federal Constitution, but it also violates the State of Pennsylvania's Constitution and its express admonitions that, quote, all men are born equally free and independent, having certain inherent and indefeasible, meaning you can't get away with it, indefeasible, you can't defease it, it can't be thrown off, right. Article 1, Section 1 of Pennsylvania's Constitution. And that, quote, neither the Commonwealth of Pennsylvania nor any political subdivision thereof shall deny any person the enjoyment of any civil right, nor discriminate against any person in the exercise of any of their civil rights. Article 1, Section 26. In Pennsylvania, the insolvency, meaning the poorness of a defendant, does not create a situation where there is no adequate remedy at law. In deciding whether remedy is adequate, it is the remedy itself, not the possible lack of success, that is the determining factor. This is reversed and sent back to the trial court. We have Justice Roberts, who's not our Supreme Court Justice Roberts. This is a Pennsylvania Court Justice Roberts, different guy, also named Roberts, who concurs in part. He says, I agree with the opinion of Justice Mandarino that appellant's indigency, the appellant not having money, does not justify the Superior Court's radical departure from the long-standing rule that equity will not enjoin a defamation. He quotes from Hellman versus Union Canal Company, an 1860 case, in which the court said, quote, the fact, if it be so, that this remedy may not be successful in realizing the fruits of a recovery at law, on account of the insolvency, the poorness of the defendants, is not itself a ground for the equitable interference. The remedy is what is to be looked at. If it exists, it is ordinarily adequate. It is possible want of success is not a consideration. So what they're saying is, if the equitable, adequate remedy is money damages, a couple $100, $1,000, whatever, and the person who's doing the wrong here is homeless, indigent, has no money, right? The fact that they can't pay the money does not mean the court can't try to do that remedy. We can't say, oh, you can't even go to court because the remedy's not available because they're poor. No, we treat everybody equal. We treat Donald Trump. We treat Elon Musk. We treat Jeff Bezos. We treat homeless cat lady on the street the same in the court of law. We have to proceed as if all these people are equal when we sue them for doing bad stuff. So we can't just say, oh, it's homeless cat lady from The Simpsons, so we can't sue her. No, you can, because it has to be equal under the law. Okay. Money damages are adequate to recompense the plaintiffs for any losses they have suffered as a consequence of the defendant's defamatory publication. Thus, it was improper to grant equitable relief based upon the appellant's presumed inability to pay the monetary judgment. The Superior Court conditions the appellant's right to a trial by jury on her economic status, the fact she's poor. That's not right. One of the underlying justifications for equity's traditional refusal to enjoin defamatory speech is that in equity, all questions of fact are resolved by the trial court rather than a jury. Thus, it deprives the appellant of her right to a jury trial on the issue of truth of the falsity of her speech. The right to a trial by jury is more than a mere form. Justice O'Brien joins in the concurring opinion. Now we have Justice Egan, who dissents, but they have like two sentences of it. So let's see What they included from Justice Egan's dissent. I dissent for the reasons articulated in my dissenting opinion of Goldman Theaters, which is not quoted. Thanks for making me pay $300 for this textbook that doesn't even include the relevant opinions, by the way. Thank you, law school. Thank you, publication of Lackock and Hastings' Modern American Remedies. Thanks for not even including the relevant material. There's a place you can go, and it's not Bermuda. I'll tell you what. Quoting Chief Egan. That opinion argued that prior restraints consist only of administrative or licensing schemes to operate before the first publication of a statement, and that prohibition, even on the narrow class of prior restraints, is not absolute. That's all they put. This dude wrote a six-page dissent, and they have less than a full English sentence. And we're paying money for these books. Nixon Larson, also justices, dissented without an opinion. Well, how about we get the dissenting opinion of the guy who actually dissented? Wouldn't that be lovely? It would be lovely. We don't have that because space and time and stuff. We're not doing that. If I'm paying $385 for a book, could it be twice this fat and have all the opinions that are relevant to my legal education in them? Maybe it could. Hard to say. Hard to say. All right. Last case for tonight, folks. eBay. You know what? Fucking whatever. Okay. I'm going to take a second. Just bring it to another case, bring it to another court. Who gives a shit? Does that mean we won, chat? Hey, chat, did we win? Some of them? If we got like 3 or 4, we win thousands of dollars still. For real. We don't need them all. Balls. Tomorrow night, we're going to win big. Ohio Lottery, everybody. Ohio Lottery. You got to play to win. We're not winning the damn thing. All right. eBay versus Mercecchange LLC. Justice U.S. Supreme Court decision from 2006. Right when I was still in the Marine Corps, so I wasn't paying any attention to this stuff. But apparently eBay, yep, Justice Thomas delivered the opinion of the court. Hail Satan. All right. Petitioner eBay operates a popular internet website that allows private sellers to list their goods which they wish to sell, either through an auction or also at a fixed price. Respondent Mercecchange holds a number of patents, including a business method patent for an electronic market designed to facilitate the sale of goods between private individuals by establishing a central authority to promote trust among participants. Mercecchange sought to license this patent to eBay, as it had previously done with other companies, but the parties failed to reach an agreement. Mercecchange subsequently filed a patent infringement suit against eBay. A jury found that Mercecchange's patent was valid and that eBay had infringed upon that patent, and that there was an award of damage that was appropriate. The trial judge refused a permanent injunction to stop eBay from doing eBay stuff. The Federal Circuit reversed the injunction to stop eBay from doing eBay stuff. All right. 2. Dose. According to well-established principles of equity, a plaintiff seeking a permanent injunction must satisfy a 4-factor test. before the court will grant such relief. A plaintiff must demonstrate, one, that it has suffered an irreparable injury. 2, dos, that remedies available at law, such as monetary damages, are inadequate to compensate for that sustained injury. 3, that considering the balance of hardships between the plaintiff and defendant, a remedy in equity is warranted. And 4, the quattro, that public interest would not be disturbed by a permanent injunction. Citing Weinberg and Romeo Barcelio, a 1982 case, and Amico Production versus the Village of Campbell, a 1987 Supreme Court case. The decision to grant or deny permanent injunctive relief as an act of equitable discretion is done by the district court, and it's reviewable only on appeal by abuse of discretion. So we're talking about a standard here, right? The standard is abuse of discretion, meaning that the trial court went so out of its noodles that we can't say that anything it did made any sense at all. So we have to whoa! That's a very high standard to meet. There's a thing called clear error, harmless error. So clear error is the court clearly erred. Harmless error is the error, but it didn't matter. Abuse of discretion is like you had the job, you had one job to do, and you fucked it up. That's abuse of discretion. Very, very hard unless the court really does screw the pooch on the lower level. So these familiar principles apply with equal force to disputes arising under the Patent Act. As this court has long recognized, quote, a major departure from the long tradition of equity practice should not be lightly implied, end quote, citing from Romeo Barceló, the case prior. To be sure, the Patent Act also declared that, quote, patents shall have the attributes of personal property. So this is like you own a stove or a TV or a car. Patents are similar to that in the way the court considers them, right? It's 35 U.S.C. 261, which includes, quote, the right to exclude others from making, using, or offering for sale or selling the innovation of your patent. If you own the patents of the Super Soaker, other people selling your shit, sue them. They can't be doing that, right? According to the Court of Appeals, the statutory right to exclude alone justifies its general rule in favor of permanent injunctive relief. But the criterion of a right is distinct from the provision of remedies for violations of that right. Indeed, the Patent Act itself indicates that patents shall have attributes of personal property, quote, subject to the provisions of this title, which is Section 261, including presumably the provision that injunctive relief, quote, may issue, quote, only in accordance with the principles of equity, Section 283. Neither the district court nor the Court of Appeals below fairly applied these traditional equitable principles in deciding respondent's motion for a permanent injunction. Although the district court recited the traditional four-factor test, it concluded that, quote, a plaintiff's willingness to license its patents, end quote, and, open quote, its lack of commercial activity in practicing on those patents, end quote, would be sufficient to establish the patent holder would not suffer irreparable harm if the injunction did not issue from the court. But traditional equitable principles do not permit such a broad classification. For example, some patent holders, such as university researchers or self-made inventors, might reasonably prefer to license their patents out rather than to undertake the efforts to secure the financing necessary to bring their works to markets themselves. Basically, we're going to have other people make our shit for. We made this great invention. We don't have an R&D lab, but we're going to license it out to have Black & Decker or Sony or LG make the shit we invented their own and give us part of the profit. We can license out our patent. And we don't have to make it ourselves because we can't do that. Because we're a lowly university researcher, or a lowly, freaking Steve Jobs in his basement. You have to farm that work out to other people, right? So that's the issue. Okay. Such patent holders may be able to satisfy the traditional four-factor test, and we see no basis for categorically denying them the opportunity to do so. To the extent that the district court adopted such a categorical rule, then its analysis cannot be squared with the principles of equity that have been adopted by Congress. In reversing the district court, the Court of Appeals departed in the opposite direction from the four-factor test. The court articulated a general rule, unique to patent disputes, that a permanent injunction will issue once infringement and validity had been adjudged. The court further indicated that injunctions should be denied only in the unusual case, under exceptional circumstances, and only in rare instances, to protect public interest. A lot of square quotes there. Just as the district court erred in its categorical denial of injunctive relief, the Court of Appeals erred in its categorical grant of injunctive relief. Oh, Jesus. Because we conclude that neither of the below courts correctly applied the tradition, you both fucked up. You went one way, then went the other way, you both fucked up. We need it in the middle. We conclude, because we conclude that neither the court below correctly applied the traditional four-factor framework that governs the award of injunctive relief, we vacate the judgment from the Court of Appeals so that the district court can apply the framework in the first instance. Basically, like, okay, y'all fucked up. District court, you fucked up. Circuit court, you fucked up. We're taking back now to district court, but district court, you screwed up too. So smack, smack, smack. Do it right. We're going to tell you how to do it. Here's how to do it. So the district court may apply the framework in the first instance, the framework we're giving you. In doing so, we take no position on whether permanent injunctive relief should or should not be issued in the particular case, or indeed any number of other disputes arising under any of the Patent Act provisions. We hold, however, that the only decision whether the grant or deny injunctive relief rests in the equitable discretion of the district court, and that such discretion may be exercised consistent with the traditional principles of equity in patent disputes no less than in any other cases governed by such equitable standards. So now we have a brief concurrence. Justice Roberts, with whom Justice Scalia and Justice Ginsburg, they were hunting buddies, joined concurring. Roberts, Scalia, Ginsburg joined concurring. They joined the opinion of the court. Quote, from at least the earliest 19th century points, courts have granted injunctive relief upon a finding of an infringement in the vast majority of patent cases. This long tradition of equity practice is not surprising, given the difficulty of protecting a right to exclude through monetary remedies that allow an infringer to use an invention against the patentee's wishes. The guy who patented it. I patented this, you're using this, I don't want you to use it. What the hell? Court should not allow that. A difficulty that often implicates the first two factors of the traditional four-factor test. This historical practice, as the court holds, does not entitle a patentee to a permanent injunction or justify a general rule that such injunctions should issue. At the same time, there is a difference between exercising equitable discretion pursuant to the established four-factor test and writing on an extremely clean slate. Open quote. Discretion is not a whim, and limiting discretion according to legal standards helps promote the basic principles of justice that like cases should also be decided in a like manner. End quote. Quoting from Martin v. Franklin Capital Corp. 2005 case, U.S. Supreme Court. When it comes to discovering or discerning and applying these standards in the area as to others, open quote, a page of history is worth a volume of logic. Close quote. End of the opinion that's cited there. Well, thanks for playing, book. Again, we pay $400 for this book. Maybe it could include all the full opinions. Wouldn't that be nice? But that's what we got for that case, and that's where we're at for the end of today, folks. If there's confusion, it's the author, editor, Mr. Laycock and Hansen's editing that's left us somewhat wanting for the opinion. But basically saying that the people who sued eBay saying, hey, we thought of eBay before eBay was a thing. They're like, well, okay, but that only goes so far. How much was your eBay like eBay? Just like how much was your Facebook than the social media movie? I don't know if you saw social media, that movie. How much was your Facebook at Yale or at Princeton or MIT? How much was that actually like Facebook is? We have to do a comparison and see what the equities balance is to how this is going forward. And we're not just going to say, oh, yeah, you had a thing that was kind of like eBay, but nobody liked it. And so now you can see eBay, sue eBay for making your idea 20 years ago better and actually marketable, right? And the dissent says we need to actually hold that up and look at actual equitable remedies, which take into account a lot more factors than just like, I had this idea years ago. Let's look at the marketability of it, the feasibility of it, the tangential ability for it to be implemented right in the actual stream of commerce. And that's where the court rests. And that's where we end for tonight, folks. So, kind of an unsatisfying end, but that's the stupid fucking book we have. So, sorry. Appreciate y'all. Have a good night. Tip your bartenders, tip your waitresses. Love you. Bye.